Okay, so Mr. Rogers, you may begin, please.
Thank you, Your Honor. If it would please the court, as I mentioned, I will read first the terms of the mediated settlement agreement into the record before calling witnesses. I would like to state for the record that the first several bullets of the MSA related to the period of time between the mediation in January and today's final. Therefore, please don't be confused by some references to those early bullets that may
You can leave those out.
I could forego those if the court and the parties are acceptable and begin with the elements that pick up with the final.
I think that'd be fine.
Keturah Havey and Travis Somerville shall be named joint managing conservators of the child with all accompanying rights and duties. The parties agree said appointment is in the best interest of the child. Lisa Gray shall be named parent possessory conservator of the child. Parties agree said appointment is in the best interest of the child. Any provision under Texas Family Code, section 153.073, 153.074, and 153.076 are subject to the supervision requirement for Lisa Gray, which is set forth below. At the final hearing, the parental rights of Father Jackie Shelton shall be terminated on O and best interest grounds only. Prior to the final hearing, the department shall facilitate a video visit with the child and Jackie Shelton. Prior to the final hearing, the department shall email photos of the child to Jackie Shelton at his email address, which I won't read into the record, and to his attorney of record, Ms. Jennifer Harris. Possession of and access to the child by Lisa Gray shall be by agreement of Lisa Gray, Keturah Havey, and Travis Somerville. Barring agreement, Lisa Gray shall have possession of and access to the child as follows. Lisa Gray may have reasonable phone calls with the child when requested by the child. Lisa Gray shall have weekly video visitation with the child by agreement of the parties. Absent agreement, the parties shall have visitation every Sunday morning at 9 a.m. local time for the child for a minimum of 15 minutes for each visit. Every effort shall be made by Keturah Havey and Travis Somerville to include the child's biological sibling in the video visit. Lisa Gray shall have supervised in-person visitation with the child in the county of the child's residence twice yearly. One visit from January to June, and the other visit from July to December of each year. In-person visitation dates are confirmed. Keturah Havey and Travis Somerville shall provide lodging in the county of the residence of the child for 3 consecutive nights for each confirmed visit. All other travel expenses shall be borne by Lisa Gray unless otherwise agreed by the parties. In-person visitation by Lisa Gray shall be supervised by Keturah Havey, Travis Somerville, or their designee, and be held for a minimum of 6 hours each day on 4 consecutive days, or other days and hours by agreement of the parties via text or email. Failure to exercise in-person visitation by Lisa Gray shall not be considered as grounds for involuntary termination of her parental rights. If Lisa Gray fails to communicate electronically with Keturah Havey and Travis Somerville for a period of 1 year, all video and in-person visitation shall cease and resume pending agreement of the parties. The parties shall use @close for all official communication. Keturah Havey and Travis Somerville may change the child's name. Keturah Havey and Travis Somerville shall make every effort to include a portion of the child's biological name in her new name. Lisa Gray shall pay $100 per month child support through the Texas Office of the Attorney General Disbursement Unit beginning June 1st, 2023. Keturah Havey and Travis Somerville shall provide medical insurance for the child. Lisa Gray shall not pay for any unreimbursed medical expenses. Keturah Havey and Travis Somerville shall pay for all unreimbursed medical expenses. Keturah Havey and Travis Somerville may apply for and receive any federal benefits to the child. No party is required to provide their physical address to the other party. And finally, the parties agree to waive the jury demand currently on file. And that concludes the immediate settlement agreement. I apologize, Your Honor, it was rather detailed, but the department will call caseworker Yolanda Griffith.
CPS caseworker.
And are you the caseworker assigned to the case we're here to discuss today?
Yes, I am.
Are you aware that the father of the child is Mr. Jackie Shelton?
Yes, I am.
Do you know Mr. Shelton's current location?
No, I do not.
Has the department had any contact with Mr. Shelton in the last 6 months in this case?
No, we haven't.
When was the last time the department had contact with Mr. Shelton, to your knowledge?
I am not aware. I've been on this case since July 2022, and since then I have never met him.
Your Honor, I'd ask the court to take judicial notice of the file, including the fact that the service plan for Jackie Shelton was made in order of the court at a hearing held on November 10th, 2021. Griffith, are you familiar with Mr. Shelton's service plan in this matter?
Yes, I am.
Was one of the elements of that service plan that he was to maintain employment or assistance to provide himself a home and healthy lifestyle?
Yes, he was.
What progress, if any, did he make toward completing that element of his service plan?
Unfortunately, none.
Was one of the elements of Mr. Shelton's service plan to engage and actively participate in a parenting course that would be incorporated into his individual therapy with Tina Nunnally?
Yes, he was.
What progress, if any, did Mr. Shelton make toward achieving that element of his service plan?
None.
Was Mr. Shelton required by his service plan to engage and actively participate in individual counseling?
Yes, he was.
What progress, if any, did he make toward that element of his service plan?
None.
Was he required to engage and successfully complete an anger management course?
Yes, he was.
Did he complete that course?
No.
Was Mr. Shelton required to complete an MHMR mental health intake and follow any recommendations?
Yes, he was.
To your knowledge, did he complete that intake?
Not to my knowledge.
Did Mr. Shelton's service plan require him to engage only with appropriate supports and not engage in illegal activity?
Yes.
What progress, if any, did Mr. Shelton make toward, excuse me, achieving that element of his service plan?
None to my knowledge.
Are you aware that Mr. Shelton was in fact incarcerated during a portion of this case?
No, I wasn't.
Okay, fair enough. I'll move on from that topic. Was one of the elements of Mr. Shelton's service plan to provide a safe, clean, and violence-free home?
Yes.
What progress, if any, did he make toward that element of his service plan?
None to my knowledge.
Was Mr. Shelton to participate in supervised visits with the child?
Yes.
Did he participate in any visits with the child?
Not while I've been on the case, no.
Which again was since, if you'll just state for the record.
July of
In
2022.
your estimation, Ms. Griffith, has Mr. Shelton complied with the terms of his service plan in this case?
No.
Is the department requesting the termination of Mr. Shelton's parental rights under Texas Family Code 161.001 B?
Yes, we are.
Oh,
Yes, sorry.
just to complete under 161.001 B10.
Yes, we are.
In your estimation, is that termination of his parental rights in the best interest of the child?
Yes, it is.
Your Honor, I have nothing further for this witness. I will probably briefly call the supervisor and also the CASA.
Harris.
All right, Your Honor, the department will call Miss Amy Brown.
Your Honor, I had some questions.
Oh, I'm so sorry, Jennifer. I didn't hear you.
Go
say
on,
it.
Miss Harris.
I apologize.
Okay, thank you. Ma'am, you said that you were aware that Mr. Shelton suffered from some mental illness?
Yes, by psychological evaluations that are in the case file.
And do you believe that the service plan was created with the knowledge and consideration of his mental health?
Yes, I believe so.
No further questions, Judge.
Okay, thank you. Next witness, Mr. Rogers.
Thank you, Your Honor. Department will call Miss Amy Brown.
Okay, Ms. Brown?
I'm a CPS supervisor here in Burnett, CPS office.
And were you the supervisor in the case that's before the court today?
Yes, sir.
And what length of time were you the supervisor in this matter?
I have been a supervisor on this case since October of
Did you
2022.
hear the questions that I asked of Miss Griffith?
Yes, sir, I did.
If I were to ask you the same questions, would your answers be any different from hers?
No, sir, they would be all the same.
In your estimation, should Mr. Shelton's rights be terminated under Texas Family Code Section 161.001 B10?
Yes, sir.
And in your estimation, is that termination the best interest?
Yes,
of the
sir, I
child?
believe it is.
I have nothing further for this witness. Thank you, Ms. Brown.
Judge, just real quickly, I think it'd be important for us to specify what the best interest grounds are. Amy, are you familiar with the current placement?
Yes, ma'am, I am.
And do you have knowledge that they have a plan for the future for this child?
Yes, ma'am.
Okay, and do they they are the adopted parents of her sister, is that right?
That's correct. Her full sister.
Right, and is it in Jade's best interest to be placed in a home that her full sister is also located in?
Yes, ma'am.
Okay, and to your knowledge, are they able to meet her physical, emotional, and psychological needs as she matures?
Yes, ma'am.
And has that been observed as well with her sister as they've had care of her?
Yes, ma'am, it has.
Okay, I pass the witness.
Mr. Rogers, next witness.
Yes, Your Honor. Department would call Mr. David Fowler.
My name's David Fowler. I'm CASA supervisor.
And have you been, in addition to being the CASA supervisor, have you also been the CASA advocate on this case?
Yes, since
And-
August 15th, 2022.
You anticipated my next question. Thank you. And have you had an opportunity to visit the child, Reveal?
Yes, sir.
Can you describe for the court your observations on the suitability of that home in the event that the court were to name Ms. Havey and Mr. Somerville, the joint managing conservators?
It's a loving and compassionate home. They are well suited to be the parent figures for Jade, as they've done with Jackie, the older sibling. It's the learning environment all as well. And then also they have continued to have OT therapy for Jade. And with my last visit, I did not see any safety hazards at all in the house or on the property.
Thank you, sir. Have you had an opportunity to observe any interaction between the child Jade and her biological sibling?
Yes,
And could you describe that interaction?
it's loving. They interact. The bonding is very strong. They play well together, though sometimes, they do have a little, this is mine and this is not yours. I'm going to take it. But they do share and share food, and they play very well together.
And is it your understanding that Ms. Havey and Mr. Somerville have adopted the older sibling of the child in this case?
Yes, sir.
Thank you. Did you have a chance to hear my rather long recitation of the mediated settlement agreement in this matter?
Yes, sir.
In your estimation as the CASA advocate, is the implementation of that mediated settlement agreement in the best interest of the child, Jade?
Yes, I do believe that Jade is going to thrive and flourish in Keturah and Travis's home.
And in your estimation, is the termination of Mr. Shelton's rights under the Family Code Section O, as we discussed previously, also in the best interest of the child, Jade?
Yes, sir.
As a CASA advocate, what is your opinion, if any, regarding the appointment of Lisa Gray as a possessory conservator with certain visitation rights, as I just recited?
I hope that she is able to continue to have a relationship with her children. And be able to come to Texas and see the children and have a nice relationship with them as they grow.
And based on that, would it be your recommendation that the court would approve the terms of the mediated settlement agreement regarding the conservatorship of the child being with Ms. Havey and Mr. Somerville, with visitation as stated to Ms. Gray?
Yes, sir.
And in your estimation, is all of that, including the mediated settlement agreement and the incorporation of the child into the home, in the best interest of the child?
Yes, definitely.
Thank you, Your Honor. I pass this witness.
Anybody have any questions, Mr. Fowler?
No, Your Honor.
No, Your Honor.
No, Judge.
Okay, thank you. Next witness, Mr. Rogers.
Your Honor, department has no further witnesses. We would move that the court would approve the mediated settlement agreement as read and enter the final judgment in accordance with its terms. Department would further move that the court would terminate the parental rights of the father, Jackie Shelton, on O grounds, and to find that such termination is the right of the best interest of the child, obviously subject to any further witnesses that are called in this case. Thank you, Your Honor.
Thank you, Mr. Rogers. Ms. Potts, do you have anything?
No, Your Honor. Thank you.
Ms. Harris?
Yes, Judge, I would ask that the department send some pictures to me, stated in the mediated settlement agreement. I have not received those. And also, the department has attempted to set up the last video visit with the child for Mr. Shelton. Because of his current living situation, income, phone situation, and more importantly, his mental health situation, we have not been able to get that worked out yet. So I would ask that the department just make one more attempt to get that set up for him.
Can y'all do that, department?
If no objection to that, Your Honor.
Why don't
We can do
we
that.
work with the interveners and try to get that done this week, and then we can just get that resolved. Okay,
And they have been very patient, Your Honor, and trying to work on getting that done.
okay, good. Thank you, Ms. Lang.
The only thing, Judge, is I want the court to know that the Couture and Travis are very much inclined to keep in touch with Uncle Ricky, and they're going to be willing to share email addresses with him, as had been discussed previously. And so I just want them, and I think Susan would also assist, to be able to facilitate the sharing of that email. So Denise, if they need anything, y'all let us know, because I think that's an important connection for the family as well.
Ms. Lang, can you put on the record why you think the MSA and the termination of Mr. Shelton's parental rights is in the best interest of Jay?
Yes, Your Honor, I absolutely. So basically, the child is in a very safe and appropriate home with her full-blooded sibling, which is very important for her. The placement has been able to consistently demonstrate that they're able to meet all of the needs of the child. The father has been absent throughout the course of this case. There's been no bonding or connection between him and the child at this time that would be severed, as is true for his older child as well. And he is not able to provide any type of demonstration of a stability to be able to engage with, understand the developmental needs of a child at the age she's only 17 months old, and has not shown and demonstrated any desire to even have a supervised contact with the child. And I believe that's part and parcel to his underlying mental health. I believe as the child gets older, the placement, if the father shows up and wants to have any contact, they'll be very protective. I think that they will be able to decide if there needs to be any contact in the future, but this time it's in her best interest for his rights to be terminated.
Okay, I'm going to name interveners as joint managing conservators, Miss Lisa Gray as possessory conservator. Visits are very detailed and as set forth in the mediated settlement agreement. The mom and the interveners are to use the app Close for all communications. I had a question about Ms. Hyde. About the MSA, it said interveners may change the child's name. Are y'all going to do that in this case, or are you going to file something later?
We would prefer to have it done in this one because that would not require a separate petition to be filed, and it would be expedite getting that new birth certificate as well.
You know what y'all want the name changed to?
Don't have that with me, but I can get that to Dwayne. Yes.
Okay, just go in and do that. I agree. That would be much easier. So we're going to change the name. The interveners are entitled to receive all federal benefits on behalf of the child. Ms. Gray pays $100 per month child support beginning June 1st of 2023. The interveners are responsible for providing health insurance and paying all uninsured, healthcare expenses. I'm going to find by clear and convincing evidence that termination of Jackie Shelton's parental rights is in Jade's best interest under Texas Family Code Section 161.001B10 grounds. Therefore, termination of Mr. Shelton's rights is ordered. Everybody is released from further representation. It's been a long case. Thank everybody for all their work on it. The case will be closed per the final order. And we are set for submission. I read that Kirsten is at a home in Temple. Doesn't sound like it's real permanent, but she's there doing okay. She wants to visit with her brother, and but apparently she's doing pretty good nowadays. So that's, and I know Ms. Potts sent me an email and says she wants to visit with me, and I just haven't been able to find time to make a plan on that one. So, Mr. Rogers, you may begin, please.
Thank you, Your Honor. I think it might be easiest if I could ask Mr. Tovar to just give us a summary of where we are. I know the placement is going well, but it is, in fact, as you state, somewhat temporary. So maybe any update on the placement search for the future?
As of right now, the department doesn't have another placement for Kirsten. We're looking for an adopted foster home, preferably. I can also say that me and Susan also did speak to Sandra Williams, the program director for Adore, yesterday, and they said that they would strongly consider keeping Kirsten so that she can at least finish out the school year, which would be around the end of May. So as of right now, we don't have anything though.
So I believe that she really likes that placement. Is that correct?
She absolutely loves it. Every time I talk to her, she tells me how much she loves it. She tells me about how she's been making friends with all the other girls in the shelter. And all of her interactions have been surprisingly appropriate compared to her friendships at Cedar Crest. And I'm very, very happy to know that she's kind of starting to live that normal teenage life now.
I assume that beyond May, that placement wouldn't be an option, or is there any hope they would make an exception to their normal practices?
I would say no. They are unfortunately an emergency shelter.
And then, Your Honor, the department, I think with regard to the mom, she's kind of been in and out on her desire to do her services. The department was wondering whether the parties would consider a mediation in this case, just to try to kind of nail down, where mom is and what she'd like to do and how she'd like to go forward. I don't believe she is represented, and she probably wouldn't be, but it might give the parties a chance to discuss kind of what her intentions are and try to get her to finalize a decision, just so that we can conclude the case in one direction or the other.
What are the odds that the mom is going to come to mediation? What are the odds that all those conservator people would come to mediation? I mean, I guess they're probably all in default. Well, it'd been served, and we hadn't seen them in a while. I don't know.
It's just I guess let me ask Mr. Tovar again. I mean, what has the Ms. Higgins done as far as engaging with her service plan at this point?
Ms. Higgins has been making, essentially no progress at each hearing. It's pretty disappointing to say the least. She has done the Teen Connect parenting program back in last year, towards the beginning of last year. And ever since then, there hasn't really been anything else besides participating in family therapy that was set up through Cedar Crest and visitations. I know that she's still living with her great grandfather, and I am sympathetic to the reason why she had to move back to him. But I know her great grandfather said that he would shoot Kirsten if she ever were to come back and try to hurt somebody in her home, which I think is just completely detrimental to her and her history. That would like to avoid a meltdown, and I would like to avoid her becoming harmed. But I would say that we're kind of just running in place with her.
We have until May on the dismissal date, Your Honor. I guess, yeah, if we're gonna mediate, we probably gotta do it pretty quickly. I guess we could inquire whether her intention is to have a role and what that role would be, and whether she'd like to relinquish or something, but we're just kind of running out of time. So we were wondering if mediation might help get her to make a final decision. But I agree, I'd hate to order it and then not have her show up and cost everybody a bunch of money.
I mean, if she's gonna relinquish, we could probably just take care of that at the trial also.
Sure, I'm just not sure we can get her to commit to that one way or the other. I think that's kind of the issue.
That read between my lines.
Understood.
Oh, Miss Peterson just said she's in the waiting room.
Oh,
She said she
here.
was.
Okay, sorry. Moto, I mean, you have to identify yourself. We've only been doing this 3 years, She hadn't figured it out by now. I'm not letting her in. I don't care. I mean, do you want me to let her in, Mr.? I mean, if that's her, do you want me to let her in?
Well, I mean, she might give us some input, Your Honor, I guess. It's
Okay.
completely up to the court.
I don't care. We're behind anyway. What's another couple of minutes? We took care of the court reporter. That's all I care about. Joining, of course, is going to take forever. Keep. Okay, well, we'll come back to her. Mr. Marino, what's up with you?
Well, Attorney Potts and I have talked about this, and she came out of Cedar Crest, went to RTC, ended up getting out of RTC with pretty positive remarks from the people there. And then she ends up at this shelter. And my understanding is that she's doing very well. While they do have their rules, Ms. Potts and I are of the belief that they might do a possible extension in the event that there's no place for her to go, because they seem to like her and she seems to be doing very well. I would, in contrast to mediation, I'd rather see DFPS help get the evaluations done so that we can lower her level of care down to moderate, which would expand the pool of houses that might be available to her. Because right now, Ms. Potts and I think she's on the high one right now. But if true what they're saying about her at the shelter, she's probably eligible to come down a little bit, and then she might have a chance to find a foster home. And based on reading the affidavit of where she came from or how she ended up under the court's jurisdiction, I'm disinclined to agree that sending her to the mother is a great idea or a good idea. I'd like to think so, but I also, Ms. Potts explained to me that Cass had reached out to an aunt and the biological sister of the biological father, and the aunt, played phone tag for a couple of times and then just dropped the whole matter. I just, if the little girl's doing well, I'm like living in a shelter. It's all relative, Your Honor. I mean, there are good shelters, there are bad shelters, but if she feels comfortable and she's going to school and she wants to go to college, I'd rather try to stay on the positive road, get her level of care down to moderate, and see if we can find her a place to live, you know, in the, I mean, we all understand that that label is keeping your average foster home from taking her on. They may not have the ability, but if she's truly doing well and gets down to moderate, there may be a family out there that would be more than willing to have her come and stay. You know, because we got 4 years that we've got to figure out what to do with here. And so, I don't know, I mean, I just think that if we're getting a positive thing out of replacement right now, that we saddled that bronc, so we should ride it for a while. I don't think mediation will really help, quite honestly.
Right. And Mr. Marino, I don't mean to put words in your mouth, but I'm going to ask you this question. Don't you think that some time there where she's at is one of the ways to get her level of care decreased?
Yeah, I think that if, you know, DFPS and Ms. Potts and I all kind of work together, we probably could get her down, you know, because she's doing well.
Right.
And the provider, from what Susan's told me, I mean, they really like her. And that's half the battle of her being in a place where they actually care.
Yeah. Yeah, that's good.
And she's talking about college, and we all know that, you know, that's an option that's open to her. And if she's finishing up school and she wants to go to college, I mean, let's build on that.
Right. Okay. I agree. Y'all, I keep letting the mother in, and you know, it's just, oh, she's here now. Whoever's on Moto, you need to identify yourself and put your correct name in here. We have no clue who you are, and we've been doing this for 3 years, and you're supposed to put your name in.
I'm trying. And let me leave and I'll come back.
We can hear you now. What's your name?
My name is Catherine Higgins.
Okay, ma'am, raise your hand. Do you swear affirm the testimony you're about to give be the truth, the whole truth, nothing but the truth, so help you God?
Yes, ma'am.
Okay, Mr. Rogers, you want to ask her some of those questions you talked about before she came on, before she was identified?
Ms. Higgins, my name is Dwayne Rogers. I represent the department, or CPS in this case. Do you understand that?
Yes, sir.
Okay. The court is trying to get an idea of kind of what your intentions are with regard to the future. Let me ask you a couple of questions. Have you participated in any individual therapy yet?
I did back when I was in Baytown, yes, but not currently here in Llano.
Okay.
I have contacted the therapist, and she had said that Raphael didn't send her the information. I've contacted Raphael. He sent her the information. I've tried to reach out to her some more, and I have not heard back from her. And the CASA worker, Miss Janet, I gave her the therapist's information, and she said that she was going to try to reach out to the therapist to try to get me scheduled to start services.
Okay. From the perspective of the court, this case has a dismissal date at the end of May of this year. So we're kind of running out of time. Would it be, if a good placement was found for Kirsten, would it be your intention to have no role in her life, a visitation role in her life, or a full role in her life? What is your intention, ma'am?
I would like to have visitation with her, and eventually custody back. Unfortunately, I'm still at my grandfather's house. I lost my job back in the first week of January, and I spent 5 weeks out of work. And currently I'm working at Dairy Queen, and they had told me full-time, and it's been no more than 25 hours a week. And I'm starting my job search over again to try to find full-time employment.
Have you been participating in the family therapy sessions?
No, sir, not since she left Cedar Crest.
Okay.
she calls me, she was calling me 2 to 3 times a week, and now it's down to like once a week, sometimes once every 2 weeks. She's just busy with teenager stuff. I believe she still is going to therapy, but they have not contacted me for any family therapy at all.
Well, thank you, ma'am. I think that is kind of the decision point for you to start making, and maybe we can communicate, or you can communicate to the caseworker and to the CASA and the ad litem, kind of about, you know, what your intentions are, and try to get some realistic options for finalizing this case. Is that understandable and agreeable?
Yes, sir.
All right, thank you, ma'am.
What about the other people? Y'all just going to plan on defaulting them? Because they're
Yes,
clearly
Your
not
Honor.
going to be back.
Correct. And they've all been served, so that shouldn't be an issue.
And Your Honor, I do have a question for Ms. Higgins in terms of, she has her son back now, Zane, from a different CPS case. And I know that Kirsten wanted to visit with Zane, and so I wanted to know what her thoughts on that were.
That is incorrect. I do not have custody of my son, Zane. That went to his father.
Okay. Well, what is his father's name? Okay. And so what would the possibility of visitations be? Do you know?
Kurt is on the road as a truck driver 3 weeks out of the month, last I heard. I have no contact with him or his wife. They don't answer my phone calls. The last I spoke to Zane, he wants nothing to do with Kirsten. When I was talking with him, he doesn't even want me mentioning her name. So the likelihood of that, under the discretion of Zane, is unlikely.
How old is Zane?
12, 13. 12.
And you don't have any custody rights over Zane?
Yes, I do.
What do you have?
He and I both have custodial rights to him, but he has primary custody.
Okay. That's all, Judge. I'm just trying to figure out how to get sibling visits if that was feasible.
Anybody else have any questions, Ms. Higgins? Ms. Higgins, do you have set visitation in that order?
Under the discretion of Zane, but it's unlikely with his dad and stepmom.
So you haven't been able to exercise any visitation?
No, ma'am. Not even phone contact. They don't answer it.
Where do they live?
Parker Heights.
That's right. I think I read that in the report. Who keeps Zane if the dad is on the road 3 weeks out of a month? The stepmom?
His stepmom.
Okay. Ms. Higgins, have you heard from Ms. Richardson or Mr. Higgins?
No, ma'am. Miss Richardson wants nothing to do really with Kirsten or Zane. The last I saw Kurt was in the court hearing with for custody of Zane, placing him back with Kurt.
So, Mr. Rogers, if y'all go to mediation, the big issue is going to be PMC or adoption, correct?
Correct.
And adoption would be if an adoptive home could be found, correct?
Correct.
Those are big issues in these type of cases. Okay, I don't have a problem. I mean, Mr. Marino, Ms. Potts, Ms. Peterson, what do y'all think about mediation?
Judge, I absolutely think that we ought to go ahead and pursue that. I mean, it's the best rule. It's the best way to get all these things ironed out. I do think that Catherine will come and be available. Be surprised if she hasn't. She's been to most of these hearings as I recall.
Okay.
Yeah, I would agree with what Mr. Rogers has said about what ought to happen. I think there's a lot of good reasons for that, most especially the danger aspect of her being put back in that home. Right. She has turned 180 degrees from what she was And every time I see her, I get this big beaming smile and a huge bear hug. And, you know, when I last saw her a couple weeks ago, I told her how proud I was of her, and I swear her face could have lit up the room. You know, she's so happy that she's gotten this far. And,
Right.
I don't want to blow it up.
Yeah, no, I think that we don't have many cases like this that we can say that about. Do we? So,
It's true. This is a good one.
okay, we'll keep our fingers crossed and try to get her level of care reduced like Mr. Marino was talking about. Okay, well, I think we'll just order mediation. Let me look at mediators. And we got to think about this type of case when we're picking a mediator.
Judge, while you're thinking, I have a question for the department, which is, I know y'all just decreased her level of care maybe 3 or 4 months ago. Do you need an order in order to have them look at that again? Or when is the projected date for looking at her level of care?
So we wouldn't need an order for us to request her to be reviewed again. It's really just as simple as me sending out an email really fast. And I feel like that, given Kirsten's progress, and I know Sandra, when she talked to us yesterday, it sounded like she would strongly recommend her be lowered to moderate. And I believe she said that, you know, her behaviors are not indicative of a child of her current level of care being so high.
Yeah.
And I really do think that we'd have strong grounds to get her lowered, and I'm willing to definitely work with her on that.
And I think that that's going to be an important, maybe just a peripheral issue in the mediation, you know, as to which fork in the road you take, you know. So I'm kind of being vague, but y'all understand what I'm talking about. I'm going to throw this out, y'all, and I know we gave him one earlier today, but Judge Prohl might be really good on this case.
Sure.
I'm good with that.
Okay. Okay, well, I don't think I need an order about the level of care. I think that's real important though. And I think y'all need to definitely discuss that before the mediation. I'm gonna say everything continue mediation with Judge Prohl before 5/10/23. That's our final trial.
Okay.
Y'all need anything else?
I don't think so.
No, Your Honor.
No, Your Honor.
And Ms. Potts, we'll make a plan with you, me and Ms. Peterson to talk to Kirsten. And y'all probably need to explain to her, get her therapist to explain to her what Ms. Higgins said about the visitation stuff.
Yes, Your Honor.
I can't remember, do you need an order to, let's say that she gets down to moderate quickly, will DFPS start looking for another placement right away?
We are already looking for placements across the state, pretty much ever since she's been placed at the shelter.
Okay.
So pretty much it would just open up her options and make it
Yeah.
significantly easier.
I'm thinking, Raphael, while we're all here, if another letter, one from her therapist and then one from the shelter to go on top of that file.
I was just thinking the same thing.
Were you? Okay, great, thanks.
Okay. Well, sounds like a good plan. Okay, well, Ms. Higgins, Mr. Ryder, you're gonna be in charge of hooking up Ms. Higgins with mediation and letting her know what it is. You have her
Yes,
email
ma'am.
or phone number for her?
Yes, ma'am.
Okay, okay, good. Okay, well, y'all, good luck, and look forward to talking to her before then, and we'll make a plan for that. And Ms. Higgins, I have to tell you, you have a service plan, you know you have to comply, your parental rights could be subject to termination. Okay,
Yes, ma'am.
okay, thank y'all.
Thank you.
And Miss Peterson, tell Kirsten the whole team's proud of her.
I will
Yeah.
do that. I will certainly do that.
Okay, today was set for a status hearing only, so I read the reports that I received, and what I got was that some folks wanted the Children's Bill of Rights implemented. It was already implemented in the adversary hearing, so we don't have to do that. The children are with the grandparents over in Llano County. The children need therapy ASAP. And The parents did not attend the family group conference, and that's the best, that's my notes from the reading the reports. So we'll just go through the attorneys. Mr. Rogers, what do you need today?
Well, obviously, because it's a status, we'd like to make the service plan in order of the court, but I'd like to ask Ms. Lancaster for the latest updates. I know this case is very complicated and it's changing rapidly. So Ms. Lancaster, could you let us know kind of where we are regarding where the children are, how they're doing, and can you maybe explain to the court the reasons that were given why the parents did not attend the family group conference?
Wait, hold on just a second, Mr. Ryder. Mr. Morris, we need to see you. Okay, thank you. Okay, go on. She can answer that question now.
Yes. Ma'am. So Autumn didn't make the family group conference because she said that her phone wasn't working. So we, since it was already so late, we had to schedule a permanency conference. And she did not attend that as well. She had attained an attorney in Corpus Christi, and he notified me that I am no longer to communicate with her and to go directly with speaking to him, and that she will not be attending. We did complete the permanency conference with both Mr. Morris and Mr. Rayline, and they both attended and are both willing to work services. We did get those set up. And so I worked on the family plan for them, so that will be submitted to the court. The children are doing great in placement. I was struggling trying to get them into therapy. Finally got Bentley into therapy, and he is scheduled to go tomorrow. They were having a hard time finding a therapist that will be able to take all three of the children and be able to work around the schedule so they all can go around the same time.
And I guess, Your Honor, the only other note that I had was that obviously a motion to transfer venue has been filed, but it's my understanding that the court intends to take that up at a different date.
Hold on, Mr. Rogers.
Yes, I apologize, Your Honor.
You know, I get real tired of these poor caregivers. They get stuff dumped on them all the time. And then everybody expects them to go find a therapist. I mean, if CPS is going to take people's kids, they need to help these folks find therapists.
Oh, I did.
Okay.
Oh,
I mean,
I did all that. Oh, yes. I
do not want the caregiver. They don't even know who's on the contract or, you know, any of that kind of mess. So was this the case I read that Mr. Henley's booked on? He didn't
yes,
have,
ma'am.
yes. He still didn't have space, or Carla in his office, or anybody else?
And they're all full, so I ended up getting him into the Phoenix Center. It just took a while for them to try to get therapists that could work with them.
Okay, and how often can they be seen? You know, stuff like that.
As far as I know this right now, that Bentley is the only one going right now, and he has an appointment tomorrow, and they're going to do weekly with Bentley.
Okay.
Because he's been struggling a lot. So I told them to hurry up and get him in at least, and then we could work on the two smaller ones to get them in with them as well.
Okay, that's great. Okay, thank you, Miss Lancaster. Mr. Rogers, I'm sorry I interrupted you, but I was on a tangent. So
not a problem, Your Honor.
Yeah.
All I was saying was that obviously a motion to transfer venue has been filed, but it's my understanding that it's not the court's intention to take that up today, but rather at a separate hearing date. And assuming that that is the case, I guess the only other thing I would ask of Ms. Lancaster is whether the department needs anything else other than the adoption of the service plans today.
And Judge, I need some clarification on my role because evidently Ms. Bryan's hired another attorney. There's been no substitution. They're the ones that filed the motion to transfer. I was court appointed. I've been told my services by my client, my services are no longer needed. So I don't know.
Okay, hold that thought. We'll get to you in just, we'll get to that. Yeah, Mr. Rogers, when I set the docket, nobody asked for a setting on that. I mean, it's not your responsibility. It's not your motion. Whoever set filed the motion needed to ask for it. So, and we're only set for 15 minutes and we're packed the rest of the day. So we'll just have to set a different hearing for that.
I thought that there was some discussion last time about the possible transfer over there because that's where the mother lives and our cases generate where mother lives. The kids were in Atlanta with the grandparents when the removal occurred.
There was discussion about that. That I can recall, but I don't remember what was decided or.
I believe
nothing was.
My recollection serves is that we were going to communicate with, like there was be like county attorney to county attorney discussion down there about them possibly accepting that case and then the communication to the presiding judge down there. So it didn't get lost in translation.
Normally when it's like, that's normally how it's done. I mean, I haven't seen a motion to transfer filed in a gazillion years, and usually, the county attorneys talk to confer or whoever does CPS representation in the other county.
I thought I saw something. I thought I saw something about a motion to transfer.
One's been filed.
It was filed. I think that's what kind of short-circuited the communication you're talking about, is that the mother has retained a lawyer who has filed a formal motion to transfer venue in the case.
And I'm contesting said motion, and I'll be filing a controverting affidavit to that effect.
Meaning that instead of a communication, we were going to have a formal hearing on it, I believe.
I think y'all can still communicate on it.
Certainly.
And which y'all can discuss. And then if we have to have a hearing, we have to have a hearing. But there you go. I mean, it's not set today anyway. So that's good. That gives everybody time for Mr. Baker files motion time for more than the 15 minutes this case is set for today. So that's good. Okay, Mr. Rogers, what else do you need?
Just to clarify, obviously, I will certainly communicate with the other attorneys on the case regarding the motion. I don't know that we'll reach agreement based on some of the positions I've heard, but we'll certainly do that, Your Honor. And other than that, just Ms. Lancaster, does the department need anything else today?
Not at this time.
Or Ms. Greenberg, you're raising your hand.
I will just communicate that we did finally approve the last remaining family plans of service, and those will be e-filed with the court today.
Okay, good. Last time we talked about Attorney General cases transferred to consolidated herein. One was in Johnson County, or maybe a couple in Johnson County, and one was in Nueces County. Was that done? Do we want to wait? Does Mr. Rogers, do you or your office know anything about that?
I know that we are working on it. Let me see if we've gotten that accomplished or not in our file.
Miss Lancaster, what are we doing? I wrote last time, hair strand on mom and the children per CPS. Hair strand on mom and the children with results returned by the hearing today. I don't recall anything about that.
The children had their hair follicle, results are not back yet. Mom and have not been able to set up her hair follicle as it's out of district. So I have to get approval, but it's been sent up to get approved.
Are the parents visiting the children?
No, ma'am. The children don't want to visit with mom. She has been having phone calls with the children, but only Bentley speaks to mom. The other two don't want to talk to her on the phone. So other than that, she has not had any visits. Her first visit that was set up, the kids refused to go. So she didn't get the visit, her first visit. After the 5 days, she didn't have her visit.
What is the status of the home study on mom's sister, Miss Barber?
I finally got all the information from her sister and her girlfriend. I had her girlfriend's information, but did not have the sister's information. But her sister finally got me the information, and I was able to set that up. Still waiting on the time and stuff like that when it's going to be completed.
And Your Honor, we apologize. There was a little bit of delay. We kind of forgot about that piece of your order. And then I think Susan Potts brought it to our attention, or maybe this other attorney, we jumped on it really quick to get it started.
Okay, where do those ladies live?
And Stephenville.
Okay, I remember that now. Also, I didn't write down which one. I just wrote Dad's release for probation records. So have you gotten that, Miss Lancaster?
No, I have not been able to get a hold of Dad. He doesn't answer my calls. He did show up to the PC conference and stated that he would start answering my phone calls or texting me because he's not allowed to have his phone at work. So I haven't been able to get anything from him regarding this probation.
My fault. I didn't write down which Dad. Which one are we talking
about? Morris, right? As Roseline, he doesn't have, and he's not on probation.
Okay. I just clarified that in my docket entry. Okay, thank you. So Ms. Dowell, we need a motion in order to substitute, correct?
Yes, and we emailed the Portland Law Office earlier this morning saying we needed a motion in order to substitute. Are they here?
It's Miss Chastain is my attorney. She's subbing in for Mr. Burlon.
Okay. What? She's subbing in for Mr. Burlon.
Okay.
Her thing is on mute, her screen. I don't think she.
I'm sorry, I can't believe I did that again. Jean Chastain is, I'm here for Mr. Burlon, Judge. I'm representing the mom, and I understand that he has filed both a plea to jurisdiction and a motion to transfer. We're concerned about mom not having any visits, and the children being pretty young, not refusing to go seems to be inappropriate. They should be able to go and meet with their mother. She wanted to have the matter transferred as soon as possible. She hasn't seen her in some time.
Ms. Chastain,
I think it is set, if I'm not mistaken.
You think it's what?
Sorry, Judge.
You said you think it's what? Set?
I understood it was set. I understood it was set, but if other counsel aren't aware of it, then maybe I'm mistaken. I thought it was set for perhaps Monday.
Oh, a visit. Is that what you're talking about?
I couldn't hear you.
A visit is set for Monday. Is that what you're saying?
That's what I was understanding, but I may have that wrong. I understood this from Bob's office.
Okay. Ms. Chastain, be sure and tell them we need I'm hearing myself in the background.
I'm sorry.
Somebody needs to turn it off. I need a motion to substitute Mr. Borlon's office for Ms. Dowell, okay?
Yes, of course.
So we can put y'all on our radar.
Yes, I understood they just found out about the hearing. I'm sorry that we weren't
that's okay.
Getting news to you that we were here.
Okay, well, FYI, that the status hearing date was announced to y'all's client on February 1st. So, we've known about this date for quite a while. So that's not y'all's fault.
Right.
Of course, each hearing is always set with the press. Okay, Mr. Baker, somebody's got to turn off.
It's Miss Chastain. I believe she needs to mute.
Okay.
I don't know.
Okay, there. Okay, thank you, Mr. Baker. Go on.
What was your question to me, Judge?
What do you need?
I have a couple of questions of Miss Lancaster.
Okay.
Miss Lancaster, you just indicated that my client is not answering your phone calls.
Yes, sir.
Are you leaving voice messages, or is that an option?
I've left a voicemail and text message.
Okay. Would you be willing to communicate with my client via text with me included on a group text?
Absolutely.
Okay. Please start a group text between you, myself, and my client. If you need my cell phone number, Ms. Greenberg has it.
Yes, sir. Okay.
All right. Just getting a thumbs up from Ms. Greenberg. All right. Thank you very much.
You're welcome.
We'll make sure that we stay in contact with you.
Absolutely.
And I believe, Your Honor, as far as, Miss Lancaster, one more question.
Yes, sir.
he hasn't had any contact with his children, right?
Not that I'm aware of, no, sir.
And that's because he's been on probation, and there's an issue with that. Is that your understanding?
Yes, sir.
Okay. All right. So it's not that he's ignoring his children, he just can't yet.
Correct.
Okay.
From my understanding, yes.
And if I get those issues fixed on his probation and he's allowed to communicate with his children and have visitations with them, I'm assuming you'll be happy to set those up.
Absolutely.
Okay. Got no further questions, Judge.
Okay. Becker, I guess you have a deadline to when you need to file your motion, your controverting affidavit and
Yes.
motion. Okay.
Per statute, Judge, I have until the Monday following 20 days to file a controverting affidavit contesting the transfer, which in this particular case would be March 27.
Okay, because I see my copy says it was filed on March 1st.
That's
Okay.
correct.
Okay, so after March 27th, we need to set a special hearing on the motion to transfer.
I would agree, Your Honor.
Ms. Bryan, you have a lawyer. We can't talk to you unless you need to go through your lawyer. Because unless your lawyer wants you to say something, but she probably doesn't, since they won't let you talk to CPS. So just text your lawyer or whatever you need to do that way to see if your issues can come out. Miss McClure, you're filling in for Miss Wheeler today, correct?
Yes, ma'am.
What does Miss Wheeler, Mr. Rogland need?
Do you mind if I ask Mr. Rogland a few questions, Judge?
No, ma'am, that's fine.
Okay. Mr. Rogland, I'm filling in for Courtney this week. It's my understanding that she had a phone call with you earlier.
Yes, ma'am. Not today, but I had reached out to her trying to get your phone number or your information, and I was not able to. So I apologize for that, and I apologize to Miss Mabray that I was not able to get in touch with my lawyer. I have a lot of things that I need to discuss with you. Now it's not the time, though.
Yeah.
Sorry.
And that's okay. She's very hard to get a hold of where she is right now, which is why I'm filling in for her. Just real briefly, why don't you tell the court, are you going to work on your service plan to do what you need to do?
Your Honor, when it comes to my service plan, I am willing to do whatever needs to be done to please the court. I've already stated, and I've worked with Sandy Lancaster over this period, that I've been nothing but helpful to her case and everything here. As it goes, I would love nothing but to see my son. But whatever you decide, I am appreciative of.
And have you seen your child since the case began?
No, ma'am.
And would you like to work with CPS to get something scheduled so you can do that?
I would be honored to see my son.
Okay. We'll go back and I'll talk to Ms. Lancaster about that in a minute. Are you in contact with her where she can get a hold of you easily and quickly?
Yes, ma'am.
Okay. And on your service plan, have they got you drug testing on your service plan?
No, ma'am. I have stated to Sandy Lancaster that I socially smoke and that I will fail a hair follicle or any test that you give me.
But that you would fail it or that you would pass?
I will fail the test.
Okay. Let's not talk anymore about that right this minute. I'll get with Miss Lancaster on that. Judge generally does order 3 clean UAs before you can see your children or your child. Are you in a place where you can get to a weekly drug test?
I can get to a weekly drug test, yes.
Okay. That's all I have with him, Judge. If I could just ask Miss Lancaster a couple of questions.
Yeah, let me ask Mr. Rogland a question. Mr. Rogland,
Yes,
where do you live? Do you work?
No, ma'am. I work with my business under my wife as a mobile dog groomer.
Okay, that's work.
Yes, ma'am.
I got it.
But I'm not licensed yet, and I'm working towards my hours to get it. It's
That's
under
fine.
my wife.
That's fine. Did you have a relationship with Dallas prior to this case beginning?
Yes, ma'am.
Okay. Do you and Miss Bryan have, I mean, there's a bunch of counties with a bunch of orders. Do y'all have a custody order in place already?
I believe so. That I may be mistaking, but I believe that in Nueces County, when I was released out of my last jail sentence that I've ever seen a jail cell for, I got out and we went to court. I did not have a lawyer, just like I don't really have one right this second.
Yes,
And
you do.
I remember signing some paperwork. I don't really remember what all it was. I can tell that I was granted rights to see Dallas, but I was given some very upsetting and angry phone calls not letting me see Dallas.
So when is the last time you've seen Dallas?
The last time I saw Dallas, was in North Carolina.
And give me a year. Approximately.
It's like 4 or 5 years ago. So,
Okay. What about phone calls, Zoom, FaceTime, any of that stuff? No.
No, ma'am. I was told that I was not to.
Okay.
I was told not to reach out in any way possible. Otherwise, my probation at the time period would have been terminated, and I was facing prison time.
What were you on probation for, sir?
Revoked probation of marijuana, a bunch of marijuana charges, and leaving the county. And I turned myself in on those charges.
No assaultive child.
No, never. I've never assaulted a child or assaulted anyone. All my charges are just for pot.
Okay. And you didn't learn, huh?
I learned that smoking pot is healthier than smoking cigarettes.
Okay. Don't answer. I'm just messing with you. Yeah, don't answer. Okay. Yeah, I know. And some of the lawyers on here I argue with about marijuana all the time because I was a prosecutor before I was a judge. So just so you know that, okay?
Yes, ma'am.
There's Mr. Baker's raising his hand. That's it. So, okay. And I'm also a prude and a nerd. So there, just add that to it too. So Mr. Baker probably wants to second that motion too. So, so sounds to me like Mr. Rogland needs to establish a relationship with his child before we just bam into some visitation. And, that's just the way I feel in a lot of these situations. So, but it sounds like the service plan is going to accommodate that and probably get into some, have them start working on a relationship. I mean, since Dallas is 6, he's able to go to some therapy and establish a relationship with his dad in a therapeutic setting. And we're not there today for status, but we'll head towards that goal. If maybe Mr. Rogland wants to write Dallas some letters or something like that can go through CASA, the Perrys, or through the department, or through Ms. Potts, I think that would be a good way to begin a relationship.
Can the ad litems in the department agree on upping that to like maybe some virtual visits and?
Probably going to have some therapeutic recommendations on that first.
Judge, I would agree because I don't know if he recalls that he has a different father,
Right.
who his father is, and so it's kind of be a shock to him. So we need to ease him into it. And I know Ms. Lancaster is working hard to get that therapy set up.
I was going to say Mr. Rogland can write child letters to go through ad litems and CPS before given to the child.
Yeah, we may want to wait because he's going to wonder what father is sending him letters.
Yeah.
And but we can keep them, and then when we get the therapist, we can go
Yeah,
back.
I added therapist also. So we'll work on that. Okay, let's see. Okay, Ms. Chastain, what do you need today?
Your Honor, we need to see if we can get, I guess with Ms. Lancaster would be the right person to get with about correcting the issue about visitation for mom. Is that correct? That's the person
Yes,
that she
ma'am.
should. We'll do
Well,
that.
let me look at my order from last time. Visits with Bentley and mom as soon as can be arranged. Other visits is agreed by children's therapist.
Were you saying that we don't have one yet, or we do have one?
I don't remember that. Is there one set up, Ms. Lancaster?
A therapist or
No,
visit?
a visit with Miss Bryan.
There was one set up with Miss Bryan, but Bentley or none of the boys wanted to meet with her.
Was it an in-person visit?
I believe so. It was done with the beginning of the case when investigation still had it.
Is a mom doing virtual visits right now?
No, she's getting to call the kids and talk to them twice a week.
Call or like, excuse me, are they able to see each other?
She can call them FaceTime if she wanted to. I'm not sure if that's what they're doing. I know they're talking on the phone, so I'm assuming she's just calling.
Your Honor, if I might, I think the reason we ordered the visit for Bentley only was because he was the only one that said he might want to see his mother. There's some very significant outcries against Miss Bryan as well as her husband. We've done a CAC. There's significant outcries there. All three children are now very adamant. They don't want to talk to their mother. I think Miss Bryan missed 2 or 3 of her phone calls with Bentley, but he does not want to talk to her anymore. They're afraid of her boyfriend, and they are very, very adamant and firm in that and have been steadfast in that. We tried with Bentley. We did the best we could, but he was the one that cut it off. And so I would request that therapist for Miss Bryan, that the visit for Miss Bryan be at the recommendation of the therapist so that we can try to repair that relationship. Because right now, those kids are saying absolutely not. They'll just.
If I can respond a little bit, Judge, as I understand it, there's been already some evidence to the department has some of the outcries are not credible. We're concerned about grandmother's has the kids in her care and is not supportive of mother having a relationship with the kids. We really need to at least allow for mother and the children to be able to talk, not on the agreement of the children, but on the recommendation perhaps of the therapist, or just setting up something where they can have a conversation. And the environment they're in is not going to be conducive to building a relationship with mother.
Right. Okay.
These children were in grandmother's care, I think, when the outcries were made, and I know our client has concerns about the credibility.
Let's just say children visit with mom in a therapeutic setting.
Yes,
and
please.
we have independent person, and we don't have people in the background or any of that kind of stuff.
Judge, can we do it at the recommendation of the therapist and then in a therapeutic setting?
Yeah. Well, because the therapists are going to have to get some rapport with the kids first. Yeah. And there's no reason to bring a bring mom into it till the therapist has rapport with the kids and see what the kids' issues are. But yeah, I think that's good. Ms. Chastain having an independent.
I just lost the sound.
Yeah. Okay. Anything else, Ms. Chastain?
No, you're all right. Thank you. We'd like to, I guess, I don't know if this is something that would be taken up with Ms. Lancaster, but my client doesn't even know where the children actually are. Is that information mother can at least have?
Yeah. I don't know. I don't understand that, but yeah.
Placement does not want the parents to know their address. They're afraid.
We're under
Come
the
on.
support, but
Are
These
they
are
in,
still my kids. Like, I deserve to know.
hold on, Miss Bryan. Are they in Llano County?
I can tell you they're somewhere in this area,
That
but
doesn't narrow it down. What county are they in?
well, if I narrow it down, they'll know where they are. But Lano,
my client's not going to do anything inappropriate. She'd like to just know where her children are. She's obtained counsel. She's appearing with the court. There's no indication that there would be any problem.
Ms. Potts, are y'all, or is it Latham's in the department more concerned about the boyfriend than they are the mother?
no, Your Honor, we have equal concerns about, or at least I do. I have equal concerns about both. We have significant outcries and we need to try to sort that out with the therapist. I really feel like, and the kids are so adamant, and I believe them. I mean, I don't know what Chris and Christy have to say. They may have a different perspective, Casa may.
How can, I guess I have to go back and read the affidavit, but it just seems weird that the kids are somewhere that the mother didn't know where they were going to be.
Well, she voluntarily, I understood, took them to grandmother. I don't know where they are now, but she voluntarily, I don't know if they met or something, but she voluntarily brought her kids for a visit, and now she's not allowed to even see them all of a sudden.
She knows they're with the grandmother and the grandparents. She knows they're there, that she just doesn't know the address.
Right. It's a whole lot has occurred once she allowed that visit to take place. So there is a lot of sorting to be done, but in the meantime, she's losing a relationship with her kids on a daily basis.
I think too, Ms. Chastain, I think the mom ought to write the kids letters too. You know, like I ordered Mr. Rogland, just to kind of work on their relationship too, to be able to go through the therapist also. She willing to do that?
Yes, Your Honor. Yes.
Okay, Harry's, what do y'all need as CASA?
I don't believe we need anything at this time. We do concur with Ms. Potts that we need some more time to figure out exactly where all the issues are here. But and we are thrilled that at least Bentley is getting therapy right now, and the other two need to go as well. That's what we heard from their teachers as well as when we spoke to them.
Okay, good. I need a hair strand on the mom like ASAP because I ordered it 2 months ago.
Where is she?
And her boyfriend. Because don't y'all have a service plan on him also? Okay. Child support, I did not see. I assume Mr. Morris and Mr. Rogline have been ordered to pay child support. Have y'all, gentlemen, have y'all been ordered to pay child support?
Yes, Your Honor, I've been ordered to pay child support. No, Your Honor, I have not been paying child support other than when I have a job to pay child support.
Right.
Like I want to let the record show once again that while I was on probation, I was told that I was not to have any contact with any of the kids, or my probation somehow would be threatened. And I was facing serious time on it.
Well, Mr. Rogland, let me just remind you, and your lawyer will tell you this too. Lack of contact does not mean lack of support.
Can I get my attorney to allow me to address, please?
Miss Bryan, you've got to talk to your lawyer, okay? I can't allow you to talk if your lawyer's going to have problems with that. Okay? And nobody laughed. Mr. Morris, what about you? Are you paying child support? I'll be able to hear you now.
Okay, I have not made a payment as of yet.
Okay, but you've been ordered, right?
Yes, ma'am.
Okay. Well, I'm gonna take that out because if y'all make any payments of child support, it needs to go to Miss Bryan because y'all are behind in y'all's child support. Okay, well, I'm just gonna leave that as is. Everybody get out pens because I have court dates. This does not include a special hearing on the motion to transfer and the controverting affidavit. Our next hearing is June 14th. Parents, y'all have service plans. You got to comply with the service plan or your parental rights could be subject to termination. Mostly today, we're about getting the parents to reestablish relationship with their kiddos and hair strands. So does anybody need anything else?
No, Your Honor.
Your Honor, no, I just assume I'll be receiving a motion to substitute.
Hope so. Yes, and Ms. Dowdle, let me know your attorney fees when you get that, okay?
I will. I'll get those calculated.
Okay, thank y'all. We'll be in recess. Please raise your
Thank you,
hand. You
Judge.
swear affirm the testimony you're about to give me the truth, whole truth, nothing but the truth. So help you go. So help you God. Okay, first permanency hearing. I read the reports. Looks like everything's going well.
They are,
So,
Judge.
rocking along. So let's just, excuse me, go through the lawyers, Mr. Baker, Mr. Wilson, what do you need today?
Thank you, Judge. Things are going well. And in fact, so well, based on the department's conversations with Ms. Tabor and with Ms. Mays about the mother, that the department's ready to propose a monitored return, let mom move back in, possibly ask for the grandmother to stick around a little to help ease that transition, but then let mom have a go at doing this on her own with Mr. Tobar, and then we watch and see how it goes.
Let me ask this. Why do we want to start that, a monitor return right off the bat when the grandma's there supervising? Do we want to just, let's say mom can move back home and do that for about a month or so and see how that goes and then start the monitor return?
Sure. I'm sure Ms. Greenberg can tell you how she feels, but that makes sense, and take things a little bit slower.
I think we get more compliance out of mom than we do grandmother.
No.
Correct me.
Well, there's that, Judge.
I mean, I'm thinking sleeping arrangements are going to be awkward because Emilio's sleeping on a couch. And so I think it's a small house. So we would like them to kind of go back into their family unit, see how they do right out the gate instead of making sleeping arrangements more awkward.
Okay, but I want her out of there. If that's what y'all want, I want her out.
Okay. We're good with that.
Your Honor, I have to tell you, I don't know that the facts are being represented correctly to the court, because I've spent a lot of time talking to CASA as well as to, Cole, and the grandmother has been no additional incidences since there were a handful of months ago. So I don't know where that's coming from. I agree with the monitored return, definitely, but I don't see any reason why grandma can't be around if that's what the family chooses to have happen. She's not been obstructive at all, according to what CPS has told us.
And
Well,
Your Honor,
Hold
my
on. If
client is
hold on, Ms. Harris. I mean, if they think they can get along as a family, then tell her to leave. I mean, I want to see how they do. What do you want to say, Ms. Harris?
my client is now working full time. That was part of her service plan. So I think that she was planning on having, my client was planning on having the grandmother assist with childcare for the time being until they get into the routine of everything.
Where's she working?
Yes.
Yes.
And Mr. Barr, him and his dad work together, right?
Correct.
You know, but I just really, I mean, grandma's going to be living there, right?
Yes.
I mean,
Not forever, Judge, but for this transition time.
Well, how long is the transition time going to go? 6 months, which is the same distance length as the monitor return? And I'm not ordering a transition monitor return. I hate
I understand. I know better than to ever ask for one again.
We all do.
Yes, I know. No, Judge, I mean, this is a family. You know, grandma was with another daughter prior to this, and they're doing family things the way they do. She's, you know, if this was any other scenario that hadn't started off bumpy, there'd be no issue. This has not been bumpy at all. Unless I've missed emails or communications, in fact, I was out there this past weekend and everybody agreed that things are going smoothly.
Yeah, we haven't heard of anything. It's just if we're asking and okaying mom to go back home, we would like to make it official and place the kids back in mom and dad's care, order the monitored return. And then if grandma wants to hang around to kind of help out with the kids in the meantime, I mean, we have no qualms, but we want our communication regarding the kids to be with mom and dad, not grandma.
That makes sense.
Yeah.
Your Honor, I'd like to say
But
something.
hold on just a second, Mr. Manning. But grandma needs to have if grandma I didn't like her attitude at the beginning of this. I mean, if y'all are over there, or anybody's over there talking to the kids, grandma needs to chill and not pull a toot on y'all.
She never has with us, so.
Not with you, but you're all warm and fuzzy. CPS is not warm and fuzzy. We know that. So I'm not warm and fuzzy. Miss McClure isn't warm and fuzzy. I got it. Okay, Mr. Manning, what do you want to say?
Yes, ma'am. I just wanted to say that all the parents involved have been doing excellent for the past few months. They've completed a co-parenting class together. And I think at this point, what would be best for the children is just getting back to that normalcy of Emilio and Jessica in the home and practicing that and evaluating how that goes, whether it's just a supervise for a month and go to a monitored return or however you want to grant it. But everybody is doing great right now.
Well, and Mr. Garcia and his girlfriend or wife went to the co-parenting too, right?
Yes, ma'am. We're really impressed by how well everybody's working together right now.
Yeah, no, I thought that was great. Okay, what does everybody else want? Miss Harris, what do you want?
I want for my client to get to go back home, Your Honor. That's about it.
That's the only thing I've written down so far. So that can happen.
I don't think that there's anything else unless my client indicates to me otherwise. I think that's just about all we've talked about. I take it back. Couples counseling has been recommended for Mr. Tobar and Jessica. And I don't think they've been able to find a couples counselor to do that yet. She met with Miss Tabor today, who indicated she could do the couples counseling if needed. So I would just like to get that set up as soon as possible to keep her moving on her service plan.
That sounds good. Is Miss Tabor her individual counselor too?
Yes, Judge.
Okay. I mean, she's willing to do it. We've got to, I mean, I think that's fine. Department, y'all okay with that?
Yes, ma'am. I sent in a referral already for couples counseling, but I can get Teresa to cancel that and just set up a new one with Deb.
Where did you send that into, Mr. Manning?
It's for counseling service out of Round Rock. I'd have to look in my referral list, but it's virtual that they can attend. But they both go to Deb, so they have a relationship with her, and I think that could be beneficial too.
Okay, that's good. We'll just do that. Okay, Mr. Wood, what do you need? Couples counseling, we got that taken care of.
Judge, I don't have it, maybe I missed it, but did the DNA testing all come back for my client as well?
Oh, I don't know that.
No, it hasn't, because I'm supposed to go the 13th of this month.
Okay.
So that's a slow moving train way behind this case, but I hope everything comes out.
Right. Mr. Tobar, do not miss that meeting, okay?
Yes, ma'am.
That's so big. Okay. Okay. Anything else, Mr. Wood?
No, Your Honor.
Miss McClure, Mr. Garcia, what do you need, Miss McClure?
Well, we would like to have more time for my client to have with his son. I'd like to see that increased. And I think that we may be in the position that we don't often find ourselves in, which is we need to go to mediation to avoid a custody battle at the end of this case. And I think that mediation sooner rather than later, while everyone's getting along, would be a good thing so that we can come up with a framework that everyone can agree to for this case to end.
except for the fact that I'm about to start a 6-month monitor return.
Well, then I would ask that based on recommendations when they come in, that the ad items in the department can make recommendations, including and up to every other week with Dad. It sounds like he's really doing well, and we're getting recommendations in on everyone. And you know, we need to know what kind of dad he's going to be while we're in this case. And the more time he can have with his son, the more we'll know, so that at mediation, we know what's best for the children.
What, excuse me, what type of visitation is Mr. sorry, y'all, Mr. Garcia getting now?
If you don't mind, it changes as they go. They increase it, and it's not a stable thing. So, Cole, could you tell us what he's doing right now?
Yes, ma'am. We worked out a step-up plan with the ad items, and right now he's completed 4 weeks of supervised visits by us and ad items, and now he's doing 4 weeks of weekend 4-hour visits, and those are supervised by family.
And everything's going well?
By his girlfriend, right?
Yes, ma'am. And I believe his mother was approved. Correct, Becky?
Correct.
Yeah.
That goes through May 7th. And then after that, our intention is to transition over to standard possession order.
We would like more than a standard possession order when this case is over.
And Your Honor, we would definitely be opposed to that. So if that's what they're looking for, then we do need a mediation at some point.
No, we're going
to
mediation. We're just not going to mediation now. So we'll make a plan on that. Okay. Miss Lane, when did you say Dad's increases to standard?
It would be after May 7th.
Okay.
He also gets 1 evening per week for 2 hours, or maybe it's 2 evenings. I forgot.
Everybody get out their pens. I'll give you a scheduling order. I'll start the monitor return now. I don't really like these dates, but that's nothing I can do about it. Next hearing is going to be 4/12. That's about a month. Maybe that'll give grandma time to move on out, and y'all and the parents can just be by themselves. Next hearing after that is 6/14, and the final is 8/9. Our dismissal date is 9/4. So it kind of weird. On the probably Miss McClure at the next hearing, I need to order mediation to occur in the summer sometime, like before July or during, before mid-July. Okay, so y'all have a plan for the dad step up. Okay. Miss Houseman, what do you need?
I just wanted to say the same thing that Cole said, that I just am really encouraged about how well everybody's getting along and working together for the best interest of the kids. I thought that the step up for Cody was going to include like 1 overnight for 4 weeks, and then we were going to move towards possibly like a full weekend. So I don't know how involved I need to be in that whole giving my opinion on that, but I do think that going slow is good, and getting Jessica back in the home is important. I don't really necessarily need anything. I just wanted to say how proud I am of everybody, and I just think everybody's done a great job. I'm excited about how everything's progressing.
Okay, great. I'm looking at the scheduling order right now. I will tell y'all that 8/9 date is going to get changed. That's advanced family law, and a lot of us go to advanced family law. So it's probably going to get bumped to another week or another day. I'm not worried about that right now. Miss Lang, what do you need?
I just want to reassure Rachel, we'll follow up on the schedule. It is true, April 12th through May 7th. We're going to the 1st, 3rd, and 5th Friday, Saturday, or Sunday overnight as agreed. And then after that period of time, Rachel, we're transitioning. We had talked about going to standard possession order, but we can talk about that further. Judge, I did receive a copy of Cody Garcia's application for court-appointed attorney, and I'm going to be asking the court to order child support. He reports a monthly income of $10,000 to $15,000, and I'm concerned that he's got a court-appointed attorney. I'd ask the court to consider having him reimburse the county for part of his attorney fees. And I did the calculation for the standard child support. The max I contemplate is $9,200 a month. And at that, the child support would be $2,113.73 a month.
Your Honor, we will just let the court know that he owns his own company. So whereas that's income, I don't know if that really talks
That's
about.
what he
the
put on his
expense.
court-appointed attorney application, judge's income. Cash income, 10,000 to 15,000.
But before the court makes a decision on that, I would like to make sure he understands what expenses are and that that's not income. Yes, he does have his own company, but most attorneys I know can't run their business real well either, as far as getting their accounting done and everything else. So he has offered to pay $400 a month, Judge. And so in the meantime, he could pay that amount while we're working on what his actual expenses are and his actual income is. And I did explain he would be ordered to reimburse some, Judge. So he already knows that. He understands that.
To reimburse the county.
Yes, I explained that to him.
Judge, I'd also like to ask for daycare for the children to be ordered from the court.
Can we get that as a standalone order, Your Honor, since we'll likely need that to get that daycare quickly taken care of.
Okay, I'm going to order Mr. Garcia to pay $500 per month child support beginning 4/1/23. Payable Ms. Lang, who will forward it to the mother. Mr. Garcia is also ordered to reimburse Llano County $150 per month beginning 4/1/23. That's payable to the Llano County District Clerk's Office for reimbursement of court-appointed attorney fees, and CPS to provide childcare.
Yeah, and the last thing, Judge, is just to re-urge definitely the couples counseling is on point. I'm glad to hear that's a focus. I spent a little bit of time with mom and dad it would be Mr. Tovar and Jessica over the weekend talking about a family budget, and definitely they need to learn, whether they're not married, but they are going to be taking care of these children. And so working together as parents to talk about finances and have an open communication about how they're going to run their household. There was some limitations in their ability to communicate about that, but I think they're going to start moving forward and working hard together. And I think couples counseling is definitely on point.
Okay, well, I'm going to order that. I know we've already talked about it. I'm not going to change the drug testing for now. Let's get into the monitor return and see how that goes. So, okay, parents, this is good hearing for y'all. Excuse me, y'all have service plans. You got to comply. Your parental rights can be subject to termination. Sounds like things are increasing for everybody in this case, and so that's a good thing. Anybody need anything else, lawyers?
Judge, I do. What did you decide about the grandmother? She has to go. She can stay.
She can stay.
All right.
We'll review it at the next hearing.
Okay. Is this a monitored return beginning now?
Yeah, I began it now. I began it now.
All right.
Start today for the scheduling order purposes.
Okay. Thank you.
Okay. Okay. Well, good luck to everybody, and we'll see y'all on 4/12. Thank you.
Thank you, Your
Judge.
All right, have fun.
Looks like things are rocking along, doing well with the kids. I read the reports and I didn't even write any notes down. So that's a good thing. Shocking. I always write notes. So what do we need to talk about today, Department? Mr. Wilson?
Well, you're right, Judge. Things seem to be rocking along. The department, at the very least, is confused and a little concerned about a couple of drug tests. Mr. Vick seems to have recently tested positive for marijuana when we thought should probably be out of his system. And then, surprise to us, William's hair test came back positive for methamphetamine. And so we don't know what to make of that. We probably just need to continue testing and keeping an eye on things, but it's definitely a concern.
Yeah.
And Judge, if I may, my client, Miss Fundus, she did her hair strand, and I think the department has called her for another hair strand. She was positive for marijuana only, and then I believe all of her UAs have been clean. She's never tested positive for methamphetamine. All of her history that we've talked about has never been methamphetamine. So when I talked to her today, she was pretty upset, angry. She wants to know what caused this as well. So I think we're just as shocked as everyone else was when that email came across, and we do want to get to the bottom of it as well.
Your Honor, I would echo those comments made by Ms. Wright. My client was surprised as well. We do know that his hair strand had marijuana because he said he had smoked marijuana, so we knew that was going to be positive. But the levels are decreasing. There was one missed time, but the reason for that was because the color and call-in had not yet been set up, and Miss Mom had taken the kids with Mr. Rudkin to do the children's hair strands, and Mr. Vick was at work. He didn't go with them. And so she did her test while she was there. He didn't know he was supposed to do a test, but they've got it set up now, and it's automated, and it's on the color, and everybody's rocking and rolling. But Mr. Vick as well was surprised and shocked at the meth coming up for William. So that was all new to us as well.
And if I can reiterate, Your Honor, like on 2.6 hair for Mr. Vick was positive at a 0.9 level. And then at 3.1, his hair came back positive at a 2.3 level. So it's low, though it's not going, it's not going down. It looks like it's gone up a little bit, but
not 2 hair strands. It was a hair strand and then a UA, right?
I have 2 hairs. I'm looking at all of them right now.
Did anybody do 2 hair strands? Mr. Vick, did you do 2 hair strands?
Mm-hmm.
He did. Okay. All right.
He did another hair strand after we found out that he had missed that one. So we wanted to cover that time frame type thing. And the level that in which William, like all the other kids were negative all around. And so the methamphetamine came at a level of like 3,500. So it's not like a little bit. It was like he's been exposed to meth somewhere along like a time frame here.
That's a lot.
And of course, Judge, my client has always tested negative. There's never been a drug history. We're all like shocked about, I think everybody on this screen was probably shocked just because it's never an issue in this case. I don't know.
I'm tired of marijuana being in this case.
I just wanted to bring it up to the court's attention that we had that come across.
Maybe somebody was over at their house that had something on it. I don't know what to think.
Or they had him over somewhere else because none of the other kids, like, did somebody babysit him and not the other kids that he was exposed? That would be my,
I don't know how you're ever going to find it out. It goes back 90 days, how do you ever figure it out? I guess everybody just stays more careful, but all the other kids didn't have any, right?
None.
I think the baby, they weren't able to test. She didn't have enough hair, but she had the UA at the hospital and it was only marijuana. So I think
what's the baby's name?
Aria.
Yeah, I don't think, no, we don't have an Aria.
If he said we're going to have to. Okay. Last time we were here, we were having bad weather, and I said the monitor return was going to start when the weather got better. When did we return the kids?
It was on February 2nd, I think. The only other concern we have, Your Honor, is Mom's insurance making it problematic for her to seek out the medical treatment. That's pretty much the root issue involved in this.
I did look at that letter, and what it said, it was for an MRI, and I think it was a facility that Dr. Forrester sent her maybe to like a non-Baylor facility. But I checked with Mom today. Her neurology appointment is still set for April. She hasn't, they haven't told her that it's changed or her insurance won't cover it. When I read that letter, though, it was that the MRI wasn't covered. So I'm hopeful that when she goes to the appointment on April 13th, they'll be able to straighten out and send her to a Baylor facility so that the insurance will cover that MRI.
Yeah, that's weird. Okay. Mr. Wilson, what else do y'all need?
I don't think there's anything, Judge.
Everybody's working out when the kiddos are with Mr. Rudkin and back and forth and all that kind of stuff.
As far as I know. Mhm.
Okay. Ms. Wright, what else do you need?
Judge, we would ask that the court consider lifting mom's supervision. She has tested, all her UAs have been negative, which indicates to me that she, as soon as this case started, she didn't have any more marijuana. She has done everything that the court has asked. She's got the kids in daycare. They get an ECI set up for the 2 kids. Aradella has missed 2 days of school, but she had a doctor's note. She had bronchitis and sinus infection. Mom has her neurologist appointment scheduled. Kiddos are scheduled. William is scheduled for his appointment with the pediatric developmental and behavioral specialist in Round Rock. She's waiting on some paperwork, but he should be seeing him soon. I mean, she's done everything. They followed the supervision, but it is very hard to have someone there with her at all times.
Did we have an ARD on Aradella?
Yes,
Yeah.
Judge.
Okay, good. Mom went to her OSAR following the recommendations.
She did. They recommended IOP, and she starts that, I believe, the 20th.
Ms. Fundis to have a psychological evaluation set up by
Yes.
CPS before today.
Scheduled before March 15th.
Okay. Okay, good. Ms. Harris?
I'm not as happy with this case as the department is and CASA is, I guess. First of all, I did not know that there had been a missed drug test until I read the status report. I should have been informed immediately. You should have been informed immediately. According to your very clear instructions, a hearing was to be held within 48 hours of a positive, dilute, or a miss. I also find it ridiculous that Mom said she couldn't start services until the children were in daycare. There's 2 other adults that are supposed to be with her at all times. She could have started doing stuff right away. As for the drug testing, I find it extremely curious that a child would test positive for meth when nobody else in the house would. I really, really want to give these parents the benefit of the doubt, but they're making it really hard because I just don't know that they understand the seriousness of this. It's not about a little bit of pot smoking. Elizabeth and William have, I can't exaggerate when I say how much they need to be seen immediately by that developmental specialist and need to be seen by ECI. Mom told me that ECI told her that they could wait until she did the developmental specialist. But when I talked to her yesterday, she didn't have an appointment with the developmental specialist yet. You spend any amount of time with especially William, who is nonverbal no matter what the parents say. I commend them for having blocks and putting on educational television and things like that for him. But he has needs that need to be met by a professional immediately and should have been done so a long time ago. I'm asking, Your Honor, that the fathers take a protective parenting course, at least at this point, because I don't think that they're all being completely honest. You know, we've got people saying that, you know, they're saying bad things to Aradella about CPS, that, you know, we've got drug tests that the levels don't match what the parents are saying to us. And we're in a monitored return now. We've got 6 months left. This is go time. We've got to start getting stuff done. And I don't think it's been done fast enough in this case. I understand some of that stuff is out of their control, but if they're serious about this and want to get these kids the help that they need, they will be on this every day, all day. I don't want the kids to be moved out of the house, but I do ask that the department inform me and the court immediately, as you had previously ordered, if there are any missed drug tests, fails, or dilutes.
Are y'all getting copies of the actual drug tests themselves?
We got them all today.
And Your Honor, I think the reason notification wasn't given about that test was because notification wasn't provided to my client that he needed to test, that just hadn't been set up yet, which was why they did the second hair strand. It was a failure on the department side or communication between them and Mr. Vick or whatever. It was one of those things that happens in the beginning of the case.
And Jamie, who's out sick, did acknowledge that miscommunications led to, the breakdown, thus the hair follicles were asked.
It was on the service plan, Your Honor, exactly what was expected, where to go, what number to call.
He didn't have a color yet though, did he?
Also,
Right.
No, he didn't have a color yet.
And at the FNC, we didn't talk about services. If y'all remember, Jamie hadn't done the FNS, whatever it's called yet.
FSNA.
We didn't talk about services. It was just, how's everybody doing? Kind of kumbaya stuff. We didn't do a service plan. So, I mean, I haven't gone over a service plan with my
Let me
client.
ask Ms. Harris another question. Ms. Harris, do you do the ECI first? Then you do the developmental specialist? I mean, I thought the ECI people then referred you out. I don't know. I don't have any cases that I know of where the kids are going to developmental specialists.
I don't know. I don't care which one goes first, as long as ECI did indicate that they could go ahead and set something up. Apparently she's been in contact with some kind of or got information for a developmental specialist. So I don't care which one it is. I think it just needs to be happening immediately.
Well, and let me ask another question. I mean, William's 3, he's about to be 4. I mean, he's out of ECI.
It's got to go through the ISD, and that's going to be a process.
I mean, the ECI was for Elizabeth, Judge, is what I wrote down. And I understood that mom has the paperwork to send in, or she was waiting on some paperwork. There's been a whole thing with changing the doctors. I don't know if it was because it went from their Medicaid to the CPS Medicaid with the TMC switch. So it's been a whole process, but to mom's credit, she has done a lot of stuff. She's gotten a lot of stuff done in just, what has it been, 30, 45 days. And while taking care of the kids, because they hadn't been in daycare the whole time. So, I mean, I feel like she's doing everything that we've asked her to do, and maybe not as fast as Miss Harris would like, but you try to schedule something with a developmental pediatrician and see how long it takes. You're not going to get an appointment very quickly.
Well, I understand, but I also understand that I've had 2 or 3 other cases with these people, and it's always been manana. So here's the order. CPS is to forward drug and alcohol test results upon receipt to attorneys in CASA, Elizabeth and William to a developmental specialist set up by mom and CPS within 2 weeks. Dads are to take protective parenting set up by CPS by 4/1/23. And I'm not going to reiterate the deal about not the drug test. I mean, Ms. Harris is right. It didn't happen. Now, whether it wasn't set up or what, I mean, that probably wouldn't have been grounds for automatic disrupted monitor return, but we should have known. So that's that I'm not going to read my order again, but that's clearly something that we need to know. Ms. Harris, what do you think about Ms. Fundus being not needing Mr. Harris, Mr. Rudkin or Mr. Vick to supervise? Because
I would be fine with that.
Mom is not to be unsupervised with all or any child at any time. Mom can be unsupervised if agreed by y'all. Only dads or persons approved in advance are allowed to supervise mom with the kids. That would mean the editors or some of those other people. But okay, go on.
I would prefer it be once she has started her IOP or get started with a therapist. But I understand we're on a shortened timeline here. The kids do love their mother. Well, it's a little hard to tell with William. He's very, very focused on what he's doing. Arya, I'm sure, absolutely adores her mom. She's sleeping when I get to see her. Elizabeth has a good relationship with her mom, and Aradella clearly loves all her parents. So I know on behalf of my kids, they would probably like as much freedom as possible.
Okay, well, and you know, after we had court, I sent a whole bunch of other orders regarding the children that need to be followed too, that I assume that we put in the orders. It was you know, about bedtime and gates and all that kind of stuff.
And Your Honor, I will say that mom is very, very much on top of Aradella's school and helping her out there. And she has the homework to show, the flashcards that they're using and all of that. So as far as Aradella, she's doing great.
That's good. That's really good news.
And she's a cute, smart little thing. She even recognizes what she does good in at school, what she doesn't do good in at school. She can talk about what her best style of learning is. They've already put into place a lot of the stuff from the ARD, and she seemed very happy with how it's all going.
Let's see, if you get on the ARDs, it's been amazing how that works good, doesn't it? Okay, so I'm gonna say Ms. Funes no longer needs supervision as long as there are no positive, dilute, or missed UAs by her or Mr. Vick, and Mr. Vick must have decreasing marijuana levels. This last time we went from 0.9 to something, decreasing. There you go. Anybody else need anything?
Your Honor, is there anything that we're able to do regarding confirmation on that hair strand test? I don't know enough about them, if they go to a second place, if we just have to test again.
Why don't we test again and see what happens?
Okay.
Because don't they do a second test when it's a confirmation, Teresa?
Yeah, they send it on for further testing just to do a confirm. So they do a screen and then they do a confirmation.
But not like a whole new sample.
Right.
Whereas
Not a whole nother sample.
Because I imagine if something was wrong with the first sample, it would be wrong in the confirmation possibly too, you know? So getting a whole nother sample maybe.
And I hate to do that to him, but I just, something about it doesn't sit right with me, you know, with both parents and all the other kids testing clean.
Well, when did we do, what was the day that the sample was taken?
2/17. So recently.
Okay. So let's do this. Let's do another hair strainer, William, after 3/17/23, and we can compare. Hopefully it will be decreasing. Obviously it'll still be there, but if it's increasing, we're going to have a big old problem. It'd be nice, let me say, with results back by next hearing. Okay. Okay, y'all have service plans. You got to comply. Oh, no. Hold on. It was done February
17th.
Yeah, Miss Harris, our next hearing is 5/10. I was thinking it was 4/10. You want to wait and do it? You want to wait and do it in April?
I'm good with that. Whatever. I hate for the little guy's hair getting cut on again, but I feel like we have to clear this up. So whenever you think is appropriate.
Let's just say, I'm not going to put a date on it. Hair strainer William again with results back by the next hearing. So probably mid-April. Then at least make sure it's gone. Probably it's gone as much as possible, but definitely down. Okay, anybody need anything else? Okay. Well,
Your Honor, just to clarify, CASA was let in on that email for the drug test last minute. It was sent to our program director before it was emailed to me, and before I was able to provide it to the CASA advocate on the case. But CASA is equally concerned about the drug tests and the results, and how this is how it was given to us late and not notified.
So I have instructed my team to send out results every Monday. She's been out sick for the last week. And so coming into court today, I did ask my admin to pull those results so that we can make sure we're all clear. And that's the reason why I got them today. I sent them today. But yes, my people are typically on top of it in terms of sending them out Monday. I know I'm getting copied some better than others. And sure, there will be some days or some weeks where, we're all human and whatnot, but we're doing our best in getting results out.
Okay, well, I'm going to add CPS for drug alcohol test results upon Monday's receipt. So I added your Monday to the order, Ms. Greenberg.
Thank you, Your Honor.
Yeah.
Sorry. I mean, we're all real concerned about where this positive test came from. And I know it's sort of unconventional, but I mean, these kids were in foster care. We could do a segmented test on William and see the time frame.
And for me, again, Your Honor, it's the same thing here. You would think that if he had been exposed to it somehow, his sister that he was placed with would have been exposed somehow.
Well, not necessarily, just because if there was exposure by picking up something off the ground, putting it in their mouth, I mean, it wouldn't be the first time we've had kids in the same house where only one tested positive and not the other. That happens.
And then, Judge, what if it was a fluke? And if we retest now, I mean, if we wait to do the test, I see the rationale for waiting, but if we retest now and he's negative, then we know it's probably just a fluke and we can go on and worry about all the other.
Let's just do hair segment. Miss Shell's got a good idea. Segmented hair strand on William this week as per CPS.
Your Honor, can you give us 2 weeks on that to get us all our?
No, next week's spring break. Nobody's going to be around.
Well, the drug testing site should be still there.
Might not. They might. No, we'll just do it this. I mean, the closer we get it to, with this situation, the closer we get it to 2/17, it's going to be better. Y'all are done with court this after today anyway. Mostly.
Ooh, okay.
I got 2 days the rest of the week.
Man, that's that. I mean, unless we don't have an order.
Man, you can get it done. You can get it done. You got to get a 2054 over there and miss.
No, it's got to go to Tim Fidel. Fidel's got to open the thing.
I ordered it.
I know, but we don't have that as a standard operating contract in our system. So we have to send either the court order or.
Oh, because it's segmented?
Yes, because it's segmented.
Okay.
It takes a little extra.
A week, Miss Greenberg. You got a week.
Thank you. Thank you, Your Honor.
Within 1 week. Okay, there you go. Okay. Okay. Good. Next hearing, what'd I say? 5:10. Okay. Good luck, everybody.
Judge, real quick, just to clarify, so you said mom no longer needs supervision as long as she's no positive, miss, dilutes, etc. on drug tests. But then you said something about Mr. Vick that I missed.
Same him. They're together. They're a package deal. And his marijuana levels need to be going down.
Judge, I think they're both still testing positive on something, right? Just from being in their system. Because
I think mom is. I think
no. Oh, okay.
So
Sorry.
Mom had a positive hair, of course, for marijuana on 2/6, but all of her UAs, like Sonia, I believe, said, have been negative since then.
Okay. Sorry. I misread that.
Yeah, no, everybody's going down. Or
Okay.
not. Okay, good. Okay, good luck. See y'all.
Thank you.
And I don't want to see y'all before then. No. Give me a break. Okay. Bye.
Bye.